Next turn to Jon Mirowitz, Unified Sportsmen.
Members of the committee, thank you for the opportunity to present you this morning. I have a little problem with some of the testimony we've heard so far. Florida does have a reciprocity. Pennsylvania does recognize anybody's permit from another state and says under section 6109, if you have a permit from another state, we will let you transport throughout the state. That's one of the exceptions. 6106. Transporting in a motor vehicle. To that extent, you don't have any reciprocity agreement. It's the reciprocity agreement that seems to be the gist of this issue. Representative Lentz, you were on Channel 29 this morning, and you were talking about the association, your concern about the association. Last time I looked, the U.S. Constitution gave me the right of freedom of association. I can associate with whoever I want. Now, if you want to throw Second Amendment rights and First Amendment rights under the bus, you know, that's something entirely different. And that, I don't think, is what this issue should be about. I don't think you would be able to get that concept past the legislature or past an American electorate. I could be wrong. What do I know? I'm just a Philadelphia lawyer. In any event, one of the other things that's been mentioned here today is about the habitual drunkard. Well, Florida's permit, you can't get a Florida permit if you're an habitual drunkard. It's one of the grounds for denial.
Just to interject, that's if there's actually a question on the application, are you a habitual drunkard? So if you were to answer yes.
Or if their investigation came out and said, wait a minute, we have all these arrests for drunk and disorderly.
So just like if the local sheriff did that investigation, they would reach the same conclusion. But I mean, the application you're referring to is if you answer, yes, I'm a habitual drunkard.
No, I wasn't referring to the application, I was referring to the statutory basis for their issuance. That's one of the things that is checked, okay? Just like wherever the carriage, I would assume they do an investigation. I'm not a police officer. Ask Lieutenant King how they do their investigations. What I can tell you about is certain people, when they, Philadelphia, for example, they turn a gentleman down, they say he has a criminal record. Turns out he doesn't have a criminal record. So at the Board of L&I review hearings, they agree to issue his license. 5 years later, when the gentleman comes up for renewal, they turn him down again, citing the same criminal record, and then adding, well, you didn't tell us that our records were wrong. That's some of the guys that you're saying shouldn't be able to get these out-of-state licenses.
Was he ultimately issued a permit?
Yes. But he also had to hire me to defend. He also had to hire me and go to that expense to enforce his constitutional right. He shouldn't have. I would love to put myself out of business. When I sat on the Ryan Commission, I said that point blank. I said it on the record. And one of the things that we had on that commission, which was the Ryan Special Sessions Commission. Ryan Commission was the select committee to investigate automatic and semi-automatic firearms use in Pennsylvania. It led to Act 17, which is what we're arguing about now, some of those provisions. One of the things that came out was the single most law-abiding, demographically identifiable group in the United States was carry permit holders. More law-abiding than law enforcement officers. If I may continue.
Okay, when you're ready for questions, let me know. Thank you.
I know I stuck it in here someplace and now I can't find it. I apologize to the panel.
We got a copy of it here.
No, I was looking for my notes. Be that as it may. What we have here is a basic problem. The right to keep and bear arms has been held as a fundamental constitutional right by the U.S. Supreme Court and then held as being applicable to the states. Pennsylvania, our Constitution, since before there was the United States, provided for that and has said, that's Article 1, Section 21, and our Pennsylvania Supreme Court has said that is a fundamental constitutional right. That was in the Ortiz situation. Now, when that becomes important is what standard of review do the courts utilize when they look at a government action impacting that right? 2536, your bill says, well, we don't want Pennsylvanians to be able to get out-of-state permits unless they have Pennsylvania permits. Well, now you're legislating for the sister states as to who they can give their permits to. That's not federalism. That's extraterritoriality, and it's unconstitutional. One of the problems, as I said, the freedom of association we spoke about. The gentleman who is he's down at the bar drinking all the time. Well, if he's a violent person, if he's a violent drunk, there's going to be police interaction, and he's probably going to have a criminal record. So, and that's going to be a prohibiting factor. If he's not a violent drunk, okay, where's the problem? Is he out there with a car driving into people? No, because then he would have that criminal record. So if he likes to sit there and spend a Friday afternoon or a Friday evening and bend an elbow with his buddies, but he's not a problem drinker, where's the problem with him having a carry permit? That was one of the issues that came out in front of the Ryan Commission, and it was testified to. And that was also discussed in this committee's hearings on that proposal way back when in the mid-90s. That, what you're trying to identify is the individual who will be a problem if they have a gun. Am I correct?
Yes.
Okay. So if there's no history of being a problem, then why should you restrict their rights?
Would you consider multiple arrests to be a history of a problem? No, that didn't result in conviction. And unfortunately, I know in later testimony we're going to hear criticism of the criminal justice system, which I think is justified, that there are, particularly in communities that have much higher crime rates, there are individuals that are able to accumulate a long list of arrests without ever having a conviction. But the police know that they've arrested them multiple times for being involved in drug trafficking or any number of crimes.
I would suggest that they have all these multiple arrests and no convictions. Maybe it wasn't because they were involved in drug trafficking. Maybe it was just because they happened to live in the neighborhood. Let me give you one example.
So you,
I had a gentleman.
Finish that question now. Would you consider it that a relevant issue to consider, the fact that a person had multiple arrests in determining whether or not to issue them a permit?
Let me give you an example in answer to your question.
Okay.
And I think it's specific. Gentleman takes his car to a street side mechanic. Guy's there all the time. It's cheaper than going to a reputable shop. But, you know, change your battery, whatever. It's, for little jobs, it's fine. While he's there, there is a drug bust on the street. The testimony is everybody on the street gets hauled in, including the street side mechanic. They turn around and say, well, we saw this guy give money to the street side mechanic, and we think he's involved with this drug bust. Okay, they revoke the gentleman's permit. He's arrested. He doesn't get his permit revoked. He's arrested. It goes in front of the court, and at the preliminary hearing, there is so little evidence against this man and against the mechanic that the charges are dismissed at the preliminary hearing, where there is no question as to the weight of the evidence. Any evidence showing any of the elements of the crimes charged is sufficient to get past the preliminary hearing. Well, at the preliminary hearing, everything is thrown out. Guy goes to apply for a carry permit. They turn him down, citing that arrest. And then they say, well, even though we didn't have enough evidence to make our burden of proof at the criminal case, where the burden would be proof beyond reasonable doubt, we still think at this hearing on carry permits, we have enough evidence and we want to be able to deny this gentleman the permit. We ended up bringing out the point the fact that it was at a preliminary hearing where the case was dismissed. It was a situation where the Honorable Seamus McCafferty was the one who said there isn't enough to move forward with this because he was sitting on the bench at the time. And the gentleman had his permit. But the point is, again, here is an individual that this character and reputation, this arrest record, this non-event, non-disabling criteria are being used to deny somebody a constitutional right, and that's wrong.
But can I ask you a couple questions? First of all, we didn't give you an opportunity, or you didn't introduce yourself for the record.
Well, for the record, my name is Jon Mirowitz. I'm an attorney in Philadelphia. I am the presenter for the Pennsylvania Bar Institute on their continuing legal education, firearms seminars. I am on board of directors for Unified Sportsmen of Pennsylvania. My law practice concentrates on firearms issues, civil, criminal, and administrative.
Okay, and you gave us two examples where you, what you described what were unjustifiable denials by the Philadelphia Police Department. A person goes in your first example, and was denied. You appealed it to L&I, which is the procedure in the city of Philadelphia, and you prevailed and the person was issued a permit. Is that a fair statement?
Whether it was a denial or whether it was a revocation, that's the procedure. I have a very good success rate.
Okay, and in the second instance, the person, again, was charged with a crime. You presented evidence at a hearing before L&I. They said, you're right, issued, and his permit was issued, right? Correct?
One of those guys, remember, the police department didn't correct their database the first time and it came back 5 years later. And there is a provision in the Uniform Firearms Act that says if the issuing agent raises an issue and loses, they can't raise it again.
Okay, so, but just to keep on track, you said you have a very high success rate. So you have a high success rate of taking individuals that you believe have been, under the law, wrongfully denied a permit to carry, appealing that denial, and getting them a permit. Is that
Yes.
Okay. Now, as an attorney, if somebody came into your office and said, hey, I applied for a permit to carry, and the local sheriff of in Philadelphia, the police department, denied me that permit, would you advise a client, don't appeal it, go to Florida?
No.
Okay, so.
Now, I have had people come to me and say, I want to get a Florida permit.
Right.
That's all well and good. When I meet with people and when I do presentations for various community groups, I tell them point blank, go ahead and get a Pennsylvania permit, because the standards for a Pennsylvania permit and the standards for a Florida permit, it's easier to get the Pennsylvania one. If you are prohibited in Pennsylvania, you're going to be prohibited in Florida, because the only things that you're talking about are character and reputation and good cause, neither of which are defined terms, and they are both so vague, amorphous, as to be meaningless. Now, if you're going to restrict the constitutional right, you should have a standard to restrict it. That's why you have the objective criteria. Now, you mentioned one of the earlier testifiers, I believe it was Mr. Grady, talked about character and reputation, mental health. Well, the mental health issue is a federal issue as well as a state issue. It's another one that gets checked everywhere. Habitual drunkard is another one. Illegal alien, that gets checked everywhere because that's a state and federal issue. The point is, all of these characters throughout the country, wherever they're issued, there is a certain basic minimum standard that everybody has to go through.
Okay, but
They check the federal databases. That covers mental health, criminal records, things like habitual drunkard, because it comes under the criminal record, the outstanding protection from Abuse Act orders, domestic relations problems, citizenship status. One of the things that we haven't talked about, dishonorable discharge. That will prevent you from getting a carry permit. But there are 4 other grounds for discharges that aren't a problem.
Let me ask you, if I can, some very specific questions about Florida. You indicated that if somebody came to you as an attorney and said they'd been denied, what you would do for them is appeal to L&I, and if they're denied at L&I, you would appeal that then to the next level.
Well, I would find out why they're denied first, because sometimes you have to do restoration of rights, or you need to do things like relief from disability. And also, I make no pretense, I do not practice in Florida.